Hello, everybody. So today I'll be discussing the UK Supreme Court case in the case of Fowler versus HMRC. So though this is an old case law, however, this is important from the article on employment as well as independent personal services or business income perspective. Even the rules of interpretation have been adequately discussed in this particular case law. So let us first look at the facts of the case. So the taxpayer, Mr. Fowler, was a resident of South Africa who worked as a diver in the UK waters of the North Sea. So he was an employee engaged by a company to work as a diver in the UK waters. However, under a provision of the UK domestic tax law, the performance of his duties were treated as giving rise to income from the carrying on of a trade in the UK. So the question which was raised was which treatment should apply for the purposes of the UK-South Africa Treaty, whether Article 14 related to employment will be invoked or Article 7 related to business profits will be invoked. Now, in April 2016, the UK First Tier Tribunal examined the impact of the definition in the UK domestic law, which deemed employment income to be treated as income from a trade. And this will have a major impact on the taxability, since under the business profits article, the UK would only tax income arising from a permanent establishment in the UK. And since Mr. Fowler did not have a permanent establishment in UK, there was no tax implication. However, this view was overturned by the upper tribunal, which found in favor of HMRC. It ruled in favor of HMRC. However, on further appeal, the UK Court of Appeal agreed with the lower tribunal and held that Mr. Fowler was self-employed and in receipt of income from trade. Then HMRC appealed to the Supreme Court and the matter went up to the Supreme Court of UK. So the key issues before the Supreme Court were around the interpretation of the meaning of employment for the purposes of the South Africa-UK double tax avoidance agreement and whether Fowler's income from diving can be taxed under Article 14 or Article 7. So rules of interpretation under Article 3.2 were discussed, emphasized quite a lot in this particular case. So as a result of the appeal in May 2020, the Supreme Court issued the final decision on this matter and ruled in favor of HMRC's view that Mr. Fowler was an employee and therefore subject to the employment income article of the treaty. The court noted that the expressions in the treaty, such as salaries, wages, and other remuneration, employment, and enterprise, should be given their ordinary meaning. So the application of Article 3.2 was considered extensively. With regard to this approach, the domestic law definitions may be used unless the context otherwise requires, and where the context so require, then the rules of Vienna Convention will apply. So the domestic law which Mr. Fowler was relying on, so section 15 of that law, which was ITTOIA, it was a deeming provision which created a statutory fiction which should be followed as far as required for the purposes for which the fiction was created. This is what the Supreme Court said. So to understand properly this particular provision of the domestic tax law, it taxes the income of an employed diver in a particular manner, which is merely an adjustment to the basis of a continuing UK income tax liability. So the court concluded that since the treaty is not concerned with the manner in which taxes are levied, it would be contrary to the purposes of the treaty to redefine its scope by reference to ITT OIA, which is the domestic tax law which was being referred to. It would also be contrary to the purpose of the domestic legislation and would produce an anomalous result. So effectively, Supreme Court ruled that Mr. Fowler will be considered as an employee within the meaning of the South Africa UK Article 14 double tax treaty. And the income would be taxable as employment income in UK. So this particular case law is important for rules of interpretation under Article 3.2 as well as in the context of Article 14 and 7. So if you want to understand the rules of interpretation, I think this is one of the most recent and important case laws which you must study and go through. Whether you are a tax professional or you are preparing for your ADIT exams or LLM International Tax, this particular case law should definitely be in your study list. So thank you for watching, and do leave your comments on any practical experience on similar cases that you might have dealt with, or any other similar cases you have come across. Thank you so much. See you soon.